our guest at this event. Can you please give a little introduction of yourself?
Well, my name is Daragh O Brien. I'm the Managing Director of Castlebridge Associates. We're a data governance, data privacy, information quality consulting and training company based in Ireland. We help change how people and organizations think about information. My background, I started off wanting to be an engineer, decided I wanted to be a lawyer instead, so studied law in university, then discovered enterprise information data management projects when I was working in a phone company, and realized that there was a confluence of my skills and interests, and I've been working in data quality, data governance for the best part of 2 decades now. And when I left the phone company to set up Castlebridge, it was very much to help organizations not think about data as a technical discipline, but to think about it as a core business competence, and data privacy is a key element of that from the point of view of building trust with your customers.
Okay. In your session, you elaborate on the EU General Data Protection Regulation. Can you briefly explain what this regulation entails?
Briefly, this regulation is an update to the existing 1995 Data Protection Directive that we've had in Europe for the last 21 years. The objective of the regulation is to bring principles and practices that we've had for the last 21 years and update them, and also to increase the level of standardization across the European Union in terms of the practices, regulation, penalties, etc. So to try and get to as close as possible to one law across Europe. So some local variations will still happen, but by and large, it's going to be one law. It is updating the regulation. It's making it more fit for purpose in the modern data age, because when the 1995 directive was being drafted, Tim Berners-Lee hadn't yet gotten around to writing that paper that invented the World Wide Web. So we've had a lot of evolution since then. Spark, Hadoop, these things did not exist. So the regulation is aiming to update how we manage data, but building very much from a fundamental human rights basis, because in European law, data privacy is a fundamental right in the Charter of Fundamental Rights in the European Union, and it's also part of the treaty obligations for EU member states under Article 16 of the Treaty for the Functioning of the European Union. So it's an explicit part of what we are as Europeans, so the regulation is there to help support that and set a benchmark standard.
Okay, so these principles are updated, or the regulations are updated. I assume the principles more or less are the same?
The principles are more or less the same. They depending on different jurisdictions, you'll have labeled them differently depending on their language. With the regulation, it's negotiated in English, it will be litigated in French, and it will be implemented in 28 languages.
Okay.
So the principles, if you want to have a listing of them, you need to process data lawfully, fairly and transparently, so communicating with people about what you're doing with their data, building that two-direction. If you want data from someone, you've got to give them a little bit of information about what you're doing with it. So building that trust. Not using the data for a purpose that you didn't tell people you're going to use it for, so limiting your purposes. So you have to think what you're doing with data in the context. Minimizing the amount of data, so only having the data you need for the purpose you have. So not gathering everything just because you can, but thinking about what you need. So you're minimizing the footprint on people's lives from the data you have. Accuracy, is it up to date? Is it correct? Having mechanisms for people to correct that. Limiting the length of time you store data for, so only keeping it for as long as you need it, and being very clear on what you do to reduce the footprint, to reduce the size of the footprint you have in people's lives with the amount of data. So not necessarily getting rid of it all, but having a plan to reduce the amount in archive, aggregate, whatever you need to do to keep running your business, but at the same time respect the privacy rights of residents of the European Union. And then you've got integrity and confidentiality, which is the old security principles. Don't let people get in to change it, and if people aren't getting in, you've got to know that they are and have ways of handling that. And finally, the key principle is accountability. It's very explicit now in the regulation. It was implied in the directive. It's explicit in the regulation now that you have to have appropriate organizational and technical controls, not just for security, but for all aspects of management and processing of personal data in your organization.
Okay. in your talk you also talk about privacy by design.
Yes. Yeah.
You explain it as in fact it's quality management applied to information.
Yeah.
Can you please give me some explanation on that?
Well, privacy by design is a philosophy of privacy management that has emerged out of Canada. So the Canadian former Data Privacy Commissioner for the province of Ontario in Canada, Dr. Ankarbukian, promoted this concept of privacy by design. Well, I'm a data quality guy at heart. So when I saw privacy by design, I went, hang on a second, what you're saying here is there's the requirement to have privacy as one of the core focuses, one of the key expectations, one of the key outputs for the design of a process, the design of an information management process. And that's all privacy by design is. It's making sure from a philosophical level in how you approach data management in an organization that you're thinking constantly about the individual who's described and defined by the data and what the impact is on them, and trying to create a win-win for the organization and for the individual in terms of things that the organization can do for the individual, but also minimizing the footprint on the impact of privacy. And it's just quality management. It's just another dimension of quality. And I've spent the last few years trying to get people to realize that these are not silos. There's a common way we can do all of these things. We've dealt with these challenges in other areas. They're not new.
So in fact, privacy is part of your information quality.
From my perspective, given that privacy, and specifically data privacy in Europe, is a fundamental right, that's the ultimate quality benchmark. If you're infringing someone's fundamental rights, you need to be very clear as to what the trade-off is and why you're encroaching into that space and what the benefit is that the individual is getting and that society is getting. And that's the ultimate quality test. Google talked about not crossing the creepy line. My personal view is that they solve that problem by moving the line every 18 months. Whereas what you need to do from a privacy by design perspective is to constantly think about how to communicate with individuals about what you're doing with their data and also respect their wishes in terms of the handling of the data.
So you talk about this creepy line, but isn't there some kind of balance? Isn't it kind of a balancing act between the pursuit of profit
and that it is always a balancing act. And with the GDPR, it's explicitly recognizing the risk-based basis for data privacy. Under the directive, it was relatively prescriptive. There were rules, and lawyers like rules, and they would go through a tick box exercise of have we complied with the rules, and that was the floor of what you needed to do. And once you stood on the floor, everyone was happy. The GDPR moves that forward because it builds in the idea of the fundamental rights being a moving target to an extent because of the pace of evolution of technology, the impact of big data, all these things. And it explicitly recognizes the risk-based model. So you're looking at the balancing of the impact on the individual and commercial activity. And the way you strike that balance is through your data governance structures and the way you manage and identify risk and mitigate risk in the organization. And the regulation explicitly recognizes that because the penalties that can be levied against you are mitigated by the quality of the structures you put in for governance. It's perfectly okay to have an accident. It's perfectly okay to misjudge something. But if you are doing the equivalent of driving down the Autobahn with 6 bottles of wine in your stomach and bald tires, the regulators are going to throw large amounts of penalties at you.
Okay, thank you for this interview.
You're welcome.